We were dealing with the appellate threshold, and I won't detain
Been and done that.
the board much longer on that. Just to summarise that, I was saying there's really only one answer, or not much room for disagreement. It's one where the Court of Appeal was in just as good a position to make the decision. So it's at the, if you like, the easy end of your Lordship's spectrum, and also the easy end of Lord Hodges' spectrum in Beacon Insurance. And so when we look at
Lord Hodges'
spectrum in
Beacon
Insurance.
Yeah.
That's paragraph 17.
Do you want to say anything about how we, as an appellate court, should approach the decision of the Court of Appeal?
Well, of course, if I'm right that it's a
Yes,
right
you haven't got a leg to
question, you might find that they're wrong, my lord.
Yes. Okay.
I think it's already been accepted by my learned friend that they had grounds on which to say there was reasonable and probable cause. I say that's right. They were right. Yes. Yeah. But in terms of what they said about the judge, paragraph 49, which is at page 526. When they say at paragraph 49, effectively the judge failed to appreciate the collective significance of the evidence because it was capable of supporting the requisite belief. And that's effectively saying the judge was wrong about the objective question, and that's a proper reason to interfere, in my submission. They're also saying it must be because he failed to appreciate the collective significance of the evidence. But the answer itself is an answer that the judge is wrong on the objective question.
You rely on both limbs. You rely on the silos point and you rely
and likewise...
but isn't the point that what the judge didn't do, they say, is look at the evidence cumulatively?
Yes, and I will go to that.
But if you look at it cumulatively, then this is the answer.
Yes. Yes,
I mean, the key word in the first sentence is collective, isn't it?
Yes, I agree.
As opposed to silos.
Yes. And also at paragraph 48, under the third, 58, under the third material error, which is at page 530, the deficiencies identified by the judge were not capable of demonstrating an absence of reasonable and probable cause. That's saying the judge got the objective question wrong. Simply not capable of demonstrating an absence.
Sorry, let's just, because what he says here is that the third material error is the judge's elevation of what he conceived to be glaring gaps.
Yes.
And deficiencies in it into proof of the absence of reasonable and probable cause.
Yes.
So, on the facts of this case,
those deficiencies were simply not capable of demonstrating an absence of reasonable and probable cause, is their conclusion at 58.
they don't sort of reason that out, though, do they?
Well, I would say they do when they then summarise the evidence and summarise their reasons for finding reasonable and probable cause.
You say the first and the third points go together, really?
They do somewhat.
And the first has got two limbs.
If we're on the objective test and it's simply wrong, yes, they do go together. But before we move on to why the Court of Appeal was right and the errors the judge made, one more point on the appellate threshold, which is the judge's fourth error, which is accepted to be an error, on the reverse burden. It's accepted that the judge erred in law in that regard, and where he relied on it is at page 360. This is just to locate your lordships and your ladyship. This is the list of significant factors identified by the judge, beginning over the page at 358, paragraph 32. A, B, C, D, E, F, and G. There are 7 significant factors identified by the judge, And F is no evidence for the lack of the requisite permits. I say, if that error is significant to the judge's assessment, and the judge says that it is, then the Courts of Appeal are entitled to make their own assessment. That alone entitles the Court of Appeal to make their own assessment. The judge identified 7 significant factors. One of them is accepted to be an error of law.
Well, I think the case against that, which is put by your opponent, is this is of such a trivial nature in the overall context that you can't just go from...
It wasn't trivial in the submissions made to the judge. It's a major factor in the submissions made to the judge.
Right.
We don't have a witness statement of Mr. Maharaj for the Magistrates' Court proceedings.
No, we have the statement he gave to Superintendent Phillip. We do have that, yes, and I will go through that when I talk about the judge's errors.
Okay.
But I mean, F is it is potentially a material one in some circumstances, but if the primary position is that it simply wasn't involved in any wrongful cutting or removing, then you don't need the permit. So it's a very much a tail end point, isn't it?
That's a fair point, my lord. The judge identifies it as a significant factor, though, and as I say, it took up a large part of the submissions and cross-examination.
So it seems to have energised the judge, but you recognise that it isn't actually that material a point in the context of the dispute.
There's simply no evidence to suggest that Inspector Maharaj felled and removed the trees, then the permit doesn't become a point.
Yeah.
But if the judge is taking them all together and saying, well, I might, it's close about trees being cut down and removed, but in any event, where's the evidence about no permits? Then it's the most important point. And the judge doesn't say, I don't need point F, by the way.
It would have been a completely different case if the case had been, well, yes, I cut these down, but I had a permit, then the case would have been a very different case.
Yes, and that's probably the way of cutting through it.
Is this the point that the judge wrongly thought that the onus was on the prosecution to prove that Mr. Maharaj did not have a license?
Yes, that's right, yes.
Therefore, a lack of evidence on that is fatal to the prosecution.
Yes, indeed, and that's why it was taken as a big point before the judge, because even if they failed on anything else, they could just knock it out with that one point.
Yes, in a sense, you would only need to take that one point.
Yes.
But that's not the basis on which the magistrates decided at half-time to knock it out.
We don't know.
Well, they may have got the law right.
I think the note submissions did mention there was cross-examination about permits. I have to have a look again at the note-based submissions, but of course we don't know which one was landed with the magistrates.
The more material point I think thought to be whether or not there was a proper case to go.
Yes. So let's move to that. And I know my learned friend's already taken you through a fair bit of the evidence that was said to amount to the case against the appellant. I'm just going to go through and just fill in a couple of extras.
Certainly for my part, I'd be grateful if you do it. If as you do that, you would put the whole thing in the context that you submit that should be seen in.
Yes, yes. First of all, in terms of a summary of all of that evidence, you can use the Court of Appeal's judgment, paragraph 6 to 16, which begins at 503. And then there's also a fuller version in the particulars of defence, pages 28 to 40. That's paragraphs A to N. And I refer to that as well because, for the reason I said before, the allegations of concoction, fabrication and duress were not pursued. So it's not in dispute that the particulars of defence are an accurate account of the evidence that was collated by Superintendent Phillips. So both of those are good summaries, in terms, especially as they're typewritten summaries, whereas some of the statements are handwritten and hard to read. But summarising the material points, we've already been through your Lordships already know that sometime in August a large number of trees were felled, and that the felling was discovered by Forestry Officer Jaggernaut on the 4th of September 2003. I'm summarising the information given to Superintendent Phillip now.
Great.
And that's Jaggernaut, page 752, Court of Appeal summary, page 503, pleaded summary, page 28. I make one point here because of the credibility of Jaggernaut, the fact that that was an issue before the judge. It was Jaggernaut and two other forestry officers who discovered the trees on 4th of September, and they both gave statements to Superintendent Phillip as well. And they are Mr. Sukdeo, that's page 766, and Mr. Sukraj Maharaj, page 780. And another point that was lighted on by the Court of Appeal, while the foresters found the trees, they found the felled trees, they started to seize them. Jaggernaut marked them with his stamp and then started to mark them and measure what was left. While they were doing that, the appellant arrived with another police officer, that was Sergeant Harnarayan Singh, to be distinguished from Sergeant Haripasad, who was there on the previous day. Harnarayan Singh is since deceased. I think that explains why he wasn't there at trial. The appellant arrived with the police sergeant, with Ramesh Narayan, who was a woodcutter, and with Boise Ali, the tractor driver. And the appellant said to Jaggernaut that he was planning to remove logs so that it would look like a thief was taking from a thief. The Court of Appeal said inferences might be drawn from the lack of credibility of that explanation. But
I don't understand what that point was. What did they mean? Inferences. What was
it's a strange
said to
explanation
be
for a police officer to give if he's coming to a forest.
But Jaggernaut explains it in his witness statement as saying what he understood, it seems, was that Mr. Officer Maharaj was saying, let's move them, and then the people who are stealing them will think that other thieves have come and are threatening to take them away, and then they'll take them away and then we'll spot them. And then Jaggernaut says, no, if they see that they've been moved, they'll scoot and they'll never come back.
Well, I would say it's a very poor way of conducting an investigation for a police officer to hide the logs. If he wanted to see who was going to come up and pick up the logs, he could just wait and see. He didn't have to hide them or pull them away and confuse the thief into thinking a thief had stolen from a thief. He just had to wait.
He wasn't hiding them, he was putting them by the side of the road.
Well, indeed. Why make it... The inference is he was putting...
What is the inference then?
That he was putting them by the side of the road so that he and his trucks could come along later and pick them up.
So then you go to the next point.
Yes. Boise Ali's evidence of this day was that the appellant had asked him to bring his tractor to come and pull some logs. Pull some logs was the phrase used by Boise Ali. I take that to mean pull some logs from within the forest to the side of the road so they're easy to pick up by a truck. And that's why Narayan the woodcutter is there, because these logs will need to be cut down to, the trees will be need to cut into logs to load them onto a truck. And after his encounter with Jaggernaut, the appellant said to Boise Ali, let's squash that deal. And Boise Ali's statement is at page 784.
So you say Boise was there to do what?
He was there with his tractor to pull trees out from the forest to the side of the road.
Yes, I'm with you.
And Narayan the woodcutter was there, presumably to make it easier to pull them.
Yeah.
So your suggestion is that Boise Ali was there, pull the logs to the side of the road, Ramesh Nareen would then cut them up, and at some point
A truck would come in. Yeah. Just as had happened before on the 30th of August on Corporal Dinu's evidence, which I'll come to. We've already been through the logs. Then a couple of days later, let's just do it. We'll go through the forestry officers. They first, having seen the felled trees in the forest, they then learnt that the next day a pile of teak logs had appeared at the side of Santa Flora police station, and they were gone the day after. And that evidence was corroborated by a number of police officers from the station. And on the 6th of September, the forestry officers found the 14 logs on the plot of land at Ragunan and Trace, which belonged to the appellant and his partner. And we've been through that evidence, and the evidence of Ricky Fiddler, who says that he saw the appellant offloading a truckload of logs onto the same land just a few days earlier. And
a few days earlier than these particular ones were being offloaded.
Yes. 30th of August is the first evidence of the appellant being in the forest and directing the removal of trees. That's Corporal Dinu's statement, which I'm about to come to. Sometime between the 1st and the 4th of September, Ricky Fiddler sees the appellant offloading a truckload of logs onto his land at Ragunan and Trace. And then on the 6th of September, so just 2 or 3 days later, up to 4 or 5, the forestry officers find a truckload of logs on the same land at Ragunan and Trace.
But on the 4th of September, the logs were still in the forest.
So somewhere. When Mr. Jaggernaut went to the forest, he found that only 13 logs remained, or 12. Many had already been removed on the 4th of September.
Okay.
Which, of course, tallies with Corporal Dinu's evidence we're going to come to. My lady, you'll recall my learned friend going through some of the log arithmetic, and he said he showed you the account where when Jaggernaut arrived on the 4th of September, 35 trees were cut, but the logs of only a few remained. They'd been removed by the 4th. And on Dinu's evidence, they were removed on the 30th of August.
Right.
And there was, I know we spent a lot of time earlier on the matching exercise. Would your lordships like me to show you how you get to 6 or 7 logs rather than 3? Because I can if you wish. But the report is at 7:44.
Does it make any difference?
Well, that's why it probably doesn't. But if you look at the last column on Lee Moon's report at page 745, it describes further logs matching the same stump. So that there's a column which shows you the first log,
Either
which
we're going to
matches
do
the
this
same
or we're
stump.
not, speaking for myself, because I don't think I can just follow it from your description.
I'll go there.
I mean, but I mean, what is the point?
Okay.
I mean, because
I can't see the documents next to each other. It's very difficult. I wonder whether it's something that could be done in writing.
Well, let's move on.
so you've got it's Deneu's evidence of the 30th of August.
Yes, and I'm going to come to that because
Okay, and then I think that you said it was the next day that there's a pile of logs outside the police station.
Yes.
That's the 31st.
Yes.
Okay, and then Fiddler's evidence relating to putting the logs onto the land opposite his and Mr. Maharaj's house was somewhere between the 1st and the 4th.
Yes.
Yes, okay.
And then the 6th is when
And then
the
you've got-
foresters find the logs on
Yes.
Inspector Maharaj's land.
Yeah.
Now, the reason I haven't come to dinner yet is because I was intending to show it in the way it developed for Superintendent Phillip, because Dinu comes later for Superintendent Phillip. When he first questions, when he questions Inspector Maharaj accepts that he encountered Jagannaut on the 4th of September, but he also alleges a first encounter on the 30th, when he says, effectively, he caught Jagannaut felling trees illegally for the minister and the senior officials. And he's supported in that by those statements from Sergeant Harry Prasad and Corporal Dinu. And of course, this was the key point for the judge, that Superintendent Phillip didn't go on to investigate that allegation. My point is that apart from the evidence I've already identified, Superintendent Phillip had good reasons for doubting the appellant's account of events or for deciding not to investigate this allegation of felling on behalf of senior officials and politicians.
Anyway, you're going to tell us what Dinu
Yes,
said.
and that's, well, of course, Dinu's evidence is one of them. But there's two more pieces. Now, I'll start with those if I may.
Oh, okay.
The first is the station diary for 30th of August 2003, which was the reason identified by Superintendent Phillip himself. That's on page 575.
This is the all clear.
Yes, all quiet.
All quiet, sorry, yes. Oh dear, it comes out.
And Assistant Superintendent Phillip, in oral evidence to the court, to the judge, yeah. So 575 says that Corporal Dinu returned at the end of the day on the 30th of August 2003. Returned to station, re-inquiries in the district, all quiet. That was the day on which Dinu and Maharaj were supposed to have encountered Jagannaut illegally felling trees on behalf of ministers.
So it's Dinu's writing, is it?
Yes, that's Dinu's writing.
Okay, okay.
No, it's not Dinu's writing, actually. It's when Dinu returns, but it's not his writing. I'll show you his writing.
No, well, don't worry. Do we know who wrote this?
No.
No. Okay.
Well, I would if I could read those signatures underneath. But,
Well, that's said to be an extract, isn't it?
oh, indeed, it's an extra.
Yeah, I mean, that's certifying it's an extract. But
Yes.
anyway, all right.
Yes.
Anyway, someone wrote that.
So, yes, Superintendent Phillip told the court that means there was nothing to investigate.
Yep.
That's what that's taken to mean. So that wouldn't be consistent with the appellant and Corporal Dinu coming across illegal logging and what the appellant said, deciding to keep the area under surveillance. I'll come to his statement shortly. He said he would keep the area under surveillance, having come across the suspected illegal logging. And you can compare it with the entrance for 4th of September, when it's common ground that he encountered Jagannaut. That's at page 578. which ends with saying it was decided that they pursue the matter. So I say that is a good point by Superintendent Phillip. The police didn't say there was anything to investigate when they came back on the 30th. And he gave that in oral evidence as a reason. It's page 302.
Was the reason what for suspecting?
For not following up
Officer
Maharaj's allegations. You were taken to the judge's finding that Assistant Superintendent Phillip deliberately avoided giving direct responses to.
Sorry to interrupt. I missed that page number.
302.
Thank you.
Now, I wish I knew which were the questions that Superintendent Phillip was said to have given generalised answers about, because the only time there's an opportunity to tell the court why he didn't investigate Inspector Maharaj's allegations, he gives it despite the fact that counsel's trying to stop him. Counsel never asks him, why did you not investigate the allegations against Atkinson and the ministers? So we take it from the top of the page, or just over the page before. Did you interview Mr. Rahel? No. Did you interview Mr. Keaton? No. And going down 10. Did you interview Mr. Atkinson? Yes, sir, I did. And that was before. And then, having gotten this information from the claimant, did you then subsequently re-interview Mr. Atkinson? That's line 17. I did not, because, question, I didn't ask you because, Mr. Phillip. So counsel's trying to stop the explanation, but Mr. Phillip insists on giving it anyway, because having checked the records as to what occurred, what he said had occurred on the 30th of August 2003, having reported off inquiries, the claimant said all was quiet and regular. And that means there's nothing to investigate. So the only opportunity Phillip has to explain why not, he gives it. He gives his explanation, and it's disregarded by the judge.
Was the entry on 578? Whose writing is that again?
578. Well, it's against certifying it's a true extract, so it won't be the original handwriting.
I see.
It's at the bottom.
Can we see the date on that? Sorry. You say it's the September the.
This is the 4th of September.
4th. Yeah.
You can see 4th of September 2003 in the bottom right corner. It's very. It's not a good copy, and the 4 is looks.
Oh yes, thank you. Yeah. Yes, thank you.
This entry is made by the station officer, is it?
The subject says Inspector has started re-inquiry, so they've returned after inquiries. Who it would have been made by, the desk sergeant, we don't simply can't say.
Yeah.
So that's the first reason why, that's the first good reason for not investigating Mr. Maharaj's allegations. The second is, of course, what the woodcutter Ramesh Narayan told Superintendent Phillip. Superintendent Phillip interviewed him, took a statement from him, in which Narayan told him that in August 2003, the appellant had hired him to cut some trees in the forest reserve. The handwritten statement is at 790. The Court of Appeal summary is at paragraph 11507. Now, Narayan recanted, saying his statement had been given under duress. Assistant Superintendent Phillip knew that it hadn't been given under duress. I remind your Lordships, there was no evidence given of duress. It wasn't put to Superintendent Phillips in cross-examination. His evidence was that Narayan willingly gave him his statement that evidence wasn't challenged. So Superintendent Phillip knew that that statement had been given to him willingly, I should say, willingly. And he also knew that when Narayan came to recant, his statement was dictated by the appellant. That was the evidence of the justice of the peace.
And when did that come into the attention of
October.
Superintendent Phillips?
I think it's October. The JP's statement is at 8:40.
So when is the cut-off date for what was in his knowledge? So when was the charge?
This is still before the charge.
I think the charge was in June 2004, wasn't
Yes, this is 23rd September 2003, so it's still within...
Yeah.
It's actually quite soon after the recantation. So the handwritten statement is hard to make, hard to read because of the handwriting and also because some of it's upside down. But there's a summary in the Court of Appeal judgment, paragraph 12, which is page 507. And the pleaded summary is at page 38. Effectively, Inspector Maharaj turned up at the JP's house with Narayan and said, we're going to give you a statement for Narayan to make a declaration. And the JP started to take dictation of Narayan's statement and protested that it was Inspector Maharaj who was dictating the statement to him. And said, if you're going to carry on, I'm going to stop writing. And eventually he did stop writing, at which point the appellant's son took up the pen and carried on taking dictation from the appellant. And the Justice of the Peace said, okay, stop. If you come back with a statement and Mr. Narayan says it's true, then he could swear a declaration before me. And so that's what they did. They came back later with a statement and Narayan swore it to be true. But what Superintendent Phillip knows is that this statement has been dictated by Inspector Maharaj. So that's another good reason not to investigate Inspector Maharaj's allegations. And the third one, and I'm sorry to come to it last, my lord, but eventually Corporal Dinu broke ranks and came clean about what actually happened on the 30th of August 2003. And he gave a handwritten, he gave a statement to Inspector Phillips, sorry, Superintendent Phillips, which is at page 802.
Sorry, when was this?
I'll get you the date is...
I've got 27th November 2003.
Yes, so it was really the last, it was the last...
For some reason I got that, I don't know why.
It's up the page.
I think it's in paragraph 10 in the Court of Appeal,
Thank you, Mark.
second line.
Yes, it's page 802. It begins at the top, 27th of November 2003. Now, this is a lengthy statement here from 802 to 814, I believe. No, 811. It's not in Dinu's handwriting. So this is written by Superintendent Phillips while interviewing Corporal Dinu. So it's evidence of an interview, not just somebody handing a statement over to him. This is an interview, and it's a long one. There's a fair summary in the Court of Appeals judgment, as my Lord Richard said, at para 10, page 505. And there's a detailed pleaded account, if the handwriting is hard, at page 35. So what did Dinu say happened on the 30th of August 2003? Inspector Maharaj told him to follow him to the forest, saying that he'd received reports of illegal felling. And 2 trucks accompanied them. And at the forest reserve, the appellant supervised the loading of logs onto both trucks. And at one point he asked Corporal Dinu, do you think these look like good logs? And he left with the loaded trucks and returned an hour and a half later with 1 truck. That truck was again loaded with logs and left. Corporal Dinu and Inspector Maharaj then followed in a police vehicle. And Corporal Dinu noticed this truck turning in a direction away from the police station. And so he asked the appellant where it's going. I suppose because the appellant had told him they were investigating illegally felled logs, so if they were removing them, he expected them to go to the police station. And the appellant told him not to worry about it. And then Corporal Dinu said he explained the statement he'd given to Inspector Maharaj. He said that once the appellant heard that Fraud Squad were investigating, he told Corporal Dinu to make a statement consistent with his account and with the statement of Sergeant Harridath Maharaj that he already had, or else they'd be in trouble. And Corporal Dinu went on to say that during the investigation, the appellant was constantly calling him, telling him if he didn't stick to his account, he would get into trouble, until eventually Corporal Dinu got annoyed and said, that's it. I think he said he got annoyed and told his wife. And then he came very soon after to Superintendent Phillip to tell him the real story. So those are 3 in my submission, very good reasons why Superintendent Phillip did not think Inspector Maharaj's allegations were worthy of investigation. And good reasons why he could rely on the other evidence, including the circumstantial evidence, tending to point to Inspector Maharaj. And very briefly summarising the key points, perhaps I don't need to. We've been through that. I'll just make this point. It's said that there was no direct evidence that Inspector Maharaj felled the trees, but there is evidence from which to infer that he was in league with the person who felled them. And as the Court of Appeal said at paragraph 51, that would be evidence of aiding and abetting the crime of felling the trees or procuring it. So that's the evidence. That's the evidence against the appellant.
So to be guilty of that offence, you don't actually have to have a chainsaw. It's enough if you arranged it, or.
Indeed.
Would it still be expressed as a charge of felling, or of aiding and abetting felling? I mean, the charge is straightforward felling, as I think I read it.
That's a question that I hadn't considered the answer to.
Sorry.
Let's have a look at what the Court of Appeal says. It's page 527. They say the charge preferred, this is paragraph 51, they describe the provision of the Accessories and Abettors Act. So it's an offence to aid, abet, counsel or procure the commission of the offence. They go on to say the charge preferred in respect of the felling of the trees would have joined the respondent in his capacity as an aider and abettor. So they don't see a problem with the charge.
Oh, he wasn't the only person charged. Yeah.
The other person charged was Narayan.
Yeah.
Of course, I keep out of account in terms of the evidence against the appellant, Narayan's statement. I mean, Superintendent Phillip did say you never know what happens when Narayan starts giving evidence in court, but you couldn't rely on that, of course. It might be a factor overall in.
The three reasons that you have submitted to us as good reasons why
Yes. Good reasons not to investigate
Inspector Phillips
the alternative.
Sorry?
Good reasons not to investigate the alternative culprit.
Were they also submitted to the Court of Appeal
Well,
as good reasons for not investigating?
well, the Court of Appeals factors are at paragraphs 47 and paragraph 50. It's page 522 and 526. They do mention they mention Narayan's evidence that's pointing Inspector Phillips, Superintendent Phillips in the right direction. And they say there's Superintendent Phillip was entitled to put the evidence of Corporal Dinu to the magistrate's court.
The reason I'm asking is that in paragraphs 57 and 58, the Court of Appeal does, I think, address this aspect, but in fairly general terms.
Yes.
But he said this is the third material error they say the judge made in what he described as glaring gaps and deficiencies. And then they comment on that there and in paragraph 58.
I think you maybe said 59 and 60 really go to the points I'm making. To the extent
Well, yes, I mean, it's quite short. I just wondered whether behind it were submissions such as the ones you've just made to us.
I'm not sure, not in the terms I've just put.
So are you saying that insofar as the Court of Appeal, or insofar as the Judge C. Prasad, relied as one of these glaring gaps and deficiencies on the failure of Officer Phillip to investigate the allegations made by Mr. Maharaj, actually it wasn't a glaring gap or deficiency because of these three things?
Yes, my lady. And there are further errors of the judge on this very point, and that's where I'm going to turn now. So, in terms of where the judge went wrong, I make one general point and a number of specific points. The general point is that the judge did not do what the Court of Appeal did and set out all the material gathered by Superintendent Phillip and then assess whether that amounted to reasonable and probable cause. I say that because of the errors he made in understanding it, and in fact he doesn't appear to have considered or appreciated all the evidence that was put before him by Assistant Superintendent Phillip. And I have a number of examples of that. First of all, the judge's judgment, paragraph 18, page 354. There's no evidence before this court to suggest that the complainant ever questioned Dinu about the contents of the statement VD1. Now, the VD1 is the statement Dinu gave to Maharaj, the one supporting his account. But as I've just shown you, Lordships and Ladyship, there was evidence before this court. Superintendent Phillip exhibited the lengthy statement he'd taken from Corporal Dinu, in which he explained why he'd given a statement supporting Maharaj and why he was now coming clean. It's a very important error by the judge that he's not even aware of that. Paragraph 19. I think this one came up this morning, but Harry Prasad should have been interviewed. Philip said he did interview him, but no statement from him was produced to this court. That's wrong. The statement was exhibited by Superintendent Philip. I think your lordships had the reference for that this morning. It's page 825.
Sorry, page?
825 is the statement that Harry Prasad gave to Philip. In paragraph 24, this is where the judge turns on to the evidence given by Jaggernaut in the magistrate's court. The court noted that the notes of evidence didn't reflect any statement of Jaggernaut was disclosed to the defence during the trial at the magistrate's court. And so it can be assumed that the evidence given by Jaggernaut before the magistrate was consistent with his statement that was on the police file, which said file would have been compiled by the complainant. If the judge is forced to make assumptions about what's in Jaggernaut's statement that he gave to Philip, it rather tends to suggest he didn't read it, even though it was exhibited to Superintendent Phillips' witness statement. And there's another pointer to the same effect at paragraph 33. This is the judge's complaint about the reliance on the evidence of thief trying to thief from thief. There was no evidence, such evidence led in the magistrate's court. If Jaggernaut had said that to the claimant, it should have been disclosed. The if, again, tells us that the judge doesn't know that Jaggernaut did say that to Assistant Superintendent Phillip. Not only that, but Superintendent Phillip put it to Mr. Maharaj for his response. That's at page 794. So this is the statement that Inspector Maharaj gives to Superintendent Phillip in response to the allegations. Page 794. And the fourth paragraph is Jaggernaut's account of the 4th of September that has been put to Inspector Maharaj. On the 4th of September, you spoke to a forest ranger, and Maharaj's answer is the final paragraph on that page. Where he says, I did encounter him. I told him about the removal of the fallen trees, and he replied, well, I've already stamped 20 as seized. And I asked him if he needed any assistance. He said no. So that's a clear indicator that the judge didn't know what was in Jaggernaut's statement to Superintendent Phillip and didn't know that had been put to Inspector Maharaj.
I'm sorry, I just didn't note down the paragraph number in the judgment. You gave us judgment para 34.
This is para 33 now.
33, thank you very much.
The complaint about the evidence.
Yeah.
I also would say about that complaint, it wasn't Superintendent Phillip's job. It wasn't his responsibility to see that that evidence was elicited in the magistrate's court. That was down to prosecuting counsel. Carrying on with the judge's judgment, just going back over the page, is at page 359. At the end of that paragraph, the court noted that although at paragraph 23 of his witness statement, Superintendent Phillip testified he interviewed several persons, including Atkinson, no statement from Atkinson was disclosed at the magistrate's court or produced before this court. That's also wrong. It was exhibited to Superintendent Phillip's statement. It's at page 747.
That's the witness statement in these proceedings before Judge CPC.
Yes. He says, no statement was produced before this court. It was produced before Judge CPC, page 747. It's exhibited to Superintendent Phillip's statement. It has the Supreme Court stamp on it. So the judge, in my submission, plainly did not familiarise himself with all of the information that was before Superintendent Phillip. And he didn't do what the Court of Appeal did, set it all out before deciding whether collectively it amounted to reasonable and probable cause. And instead, and I do say it's an error, he appears to have conceived of his task as resolving a clash of evidence between Inspector Maharaj and Forester Jaggernaut. And that's why he placed so much weight on their credibility. And you've seen the passages. I submit that was the wrong approach. It's wrong to say, from cross-examination before the judge, that Superintendent Phillips should have known that the appellant was credible and Jaggernaut was not. It's an entirely different exercise. What's more, the judge didn't say that either. He didn't say, as Lord Richards posited, that Jaggernaut was so lacking in credibility that Superintendent Phillips should never have conceived of the idea of putting him before the magistrate's court. And he didn't find Jaggernaut incredible because his evidence was full of holes or bound to fall apart, as my learned friend said. What he said was, the appellant was forthright and Jaggernaut was shifty. That's really what it came down to. That's the wrong exercise. Now, I turn to some specific errors as well. Three in particular. First is page 359, paragraph 32B. There's no nexus on the evidence between the logs that Fiddler saw being offloaded and the logs that were taken by the foresters. Well, I say that's wrong. There's no direct evidence from Fiddler that they were the same logs, but there is a nexus. The nexus is the same place and the proximity in time. Fiddler saw a truckload of logs being offloaded by the appellant onto his land. A few days later, foresters found a truckload of logs on the appellant's land. That's a nexus in my submission. And there's other relevant evidence to consider too when you're talking about circumstantial evidence, and that's the evidence that the appellant had been seen directing the removal of logs from the forest a few days before, and the evidence that some of the logs found on the appellant's land came from the same place in the forest.
That was Dinu who said that.
Yes, that was Dinu, yes. So the proposition that the logs were the same was worthy of being put to the magistrate. That's the test. And simply to say there's no nexus is it is, as the Court of Appeal said, to fail to appreciate the collective significance of all the circumstantial evidence.
There was time and location. Dinu had seen him load up the trucks a few days before. What was the other?
And that the logs, some of the logs found on the appellant's land came from the same place.
This is the matching point.
Yes.
Oh.
The second error that I would point to is what the judge says about Dinu at the next paragraph, 32C. Officer Dinu gave evidence before the magistrate that conflicted with the statement that was submitted to Alfonso. This conflict would have been known to the complainant prior to the institution of the charge. Well, of course, this arises from the judge's failure to understand that Dinu had explained everything to Superintendent Phillip. But the judge doesn't actually say what the results of this should be in terms of what weight to be given to Dinu's statement or what weight Superintendent Phillip should have given to it. But it's apparent from his other findings that he considered it wasn't something Phillip should have relied on. At least that's the impression one gets from his paragraphs 16 and 17, which are at page 353, where he goes through Dinu's evidence. So he recounts if you like, the incriminating statement and the incriminating evidence given by Dinu to the magistrate's court. And then he compares it to the statement Dinu gave, the exculpatory statement Dinu had earlier given to Maharaj. And he recounts how Dinu was cross-examined on the exculpatory statement at the magistrate's court. And he notes then how Dinu didn't fare very well in cross-examination on his earlier exculpatory statement.
The substance, that's right, isn't it? Dinu, he knew perfectly, Mr. Superintendent Phillips knew,
Yes.
Long before the trial occurred, that Dinu had made at least two completely opposing statements.
Yes.
And that he was likely to be cross-examined
For sure.
by
Yes.
reference to the first one.
He was entitled to consider the explanation Dinu had given to him for coming clean and breaking ranks, and for following what his commanding officer had told him to do earlier on the 11th of September. Inspector Maharaj was the commanding officer of the police station. Dinu did what Inspector Maharaj said on the 11th of September 2003. He then explained to Superintendent Phillip why he had done so and why he was now coming clean. And knowing that Dinu would have to explain that to the magistrate, and knowing that he might not survive cross-examination, is not the same as an absence of reasonable and probable cause. Superintendent Phillip is entitled to put that account to the court for the fact finder at the court to decide whether it's true.
I mean, this is all part of the misunderstanding by the judge to which you referred us in relation to paragraph 18. I mean, the lengthy recital in paragraph 16 of Dinu's evidence before the magistrates is actually precisely what he says in his second statement.
Yes.
Which, of course, Phillip had.
Yes.
But the judge has not realised that there was this second statement.
And the judge points out that the magistrate may not have been satisfied with Dinu's answers under hostile cross-examination, but he's not aware that Dinu's given an explanation already to Superintendent Phillip.
Sure.
So, just as...
because the magistrate doesn't know of the second statement.
The magistrate does. The magistrate, Dinu gave evidence in chief, completely in line with the second statement.
Yeah.
Yes.
Then he was cross-examined on his first statement.
Yeah.
But hang on a
Yeah.
minute, you supported Inspector Maharaj earlier.
Yeah.
Of course, hostile cross-examination, he might not fare very well.
No, but
But it doesn't mean that it's not reasonable and probable.
no, my
cause.
question was, would the magistrate have thought, my goodness, he's just coming out with this second completely different statement, or would he have known that he had actually, a short time after he gave the first statement, given a consistent statement?
Yes,
It might not matter.
I'm not sure it's a matter for examination in chief to say, I gave this statement to Superintendent
No, that's
Phillip
what I'm
a
wondering.
few months ago. The chief is meant to elicit, without the statement in front of anybody, apart from the examiner, what Dinu had said to Superintendent Phillip a few months earlier. Or in this case, several years earlier, by the time the evidence.
But you say the whole tenor of 18 is not a fair reflection of what happened. The whole tenor of paragraph 18.
No, it's a complete misconception of what happened, of what Superintendent Phillip knew. And I do say, just to reiterate, knowing that Dinu might not survive cross-examination is not the saying that there was not a case fit to put to the court. It's for the court, the magistrate, to decide whether Dinu's second statement is true. And just because there are two inconsistent statements doesn't mean that there's no case fit to put for the magistrate. Otherwise, you can never rely on the evidence of somebody who's come clean and broken ranks. And somebody who does that, somebody who backs up their fellow conspirators or their senior officer and then is persuaded to tell the truth, well, they're very important witnesses. And you can't simply say, well, there's no reasonable and probable cause to put before the court because he was once persuaded to support the wrongdoer's account. And by the same token, just as knowing that he might not survive cross-examination doesn't mean there's not a fit case to put, so too, the fact that he didn't survive cross-examination, if indeed that was the magistrate's view, is also not proof that the case was unfit. It's one of those things that might happen.
But from what other than Dinu's exculpatory statement would have led the judge to have known that his evidence, that there was a conflict in his evidence?
Because he saw what Dinu said to the magistrate's court. He didn't know that this was all...
No, but the judge says the conflict in the evidence would have been known prior to the institution of the charge. Now, I thought, what could have put the Superintendent Phillips on notice of that other than the exculpatory statement? And I agree.
Superintendent Phillip knows about the exculpatory statement. Yes, he does know about that. And he then hears the incriminating statement, and he's given an explanation for the earlier exculpatory statement. And the judge says Phillips would have known about this. Well, yes, of course. In fact, Phillips took a lengthy statement from Dinu. But that's the bit that the judge doesn't appreciate.
Yes, the real point is the mistake in paragraph 18 rather than the one here.
Yes. Save that.
Would have been.
Save that the judge is also here. When we look at 16 and 17, he's also making the error that the Court of Appeal criticised him for, of relying too much on how it came out at the magistrate's court instead of how it appeared to Superintendent Phillip. Because you cannot conclude from Dinu not surviving cross-examination that there was no case fit to put. That's not permissible. And that's what the Court of Appeal say, that paragraph 54, page 528. The judge concentrated on how it came out at the magistrate's court, which was an error. And then the third area I'll probably go through this quickly because the judge placed very great weight on Maharaj's allegations that Jagannaught and senior politicians were the real culprits. And he refers to that, as you have seen, on many occasions, such as, we're there right now, page 359 32D, 32E, and over the page at 35 when he sums up his reasons for criticising Superintendent Phillip that you've already seen. Now, in my written case, I made the point that the investigating officer doesn't have to investigate every claim made by a suspect. And I've given the references. But of course, I accept that if there's credible, cogent evidence pointing to another culprit, that could be a different matter. But in this case, as I've taken your lordships through already, the judge ignored all the reasons Superintendent Phillip had for finding Inspector Maharaj's accusations not worthy of investigation. And those are the three good reasons I gave you earlier. The judge didn't consider those. I say if he had, he would have accepted there were good reasons not to investigate that alternative accusation. But I particularly rely on the first one I mentioned. Superintendent Phillip told him why I didn't go back and investigate it, because the police said there was nothing to investigate on that day. And he had to squeeze that out despite counsel not wanting him to explain. But the judge doesn't appear to have taken that into account when he criticises Phillip for not investigating the 13th of August. Those are the errors, I say, of the judge.
I think it was Superintendent Phillips who described the station log as all quiet and regular, where in fact it's just all quiet. Yes. Now, that may just be a quibble. On the other hand, reading the station log, all quiet could, in the context of the whole of that paragraph, could it mean nothing violent going on? I mean, he'd gone out with a gun and returned, put it back in the armoury, all quiet.
Perhaps Mr. Singh should have put that to...
Well, I was going to ask you, I mean, was there any point taken on this at the trial?
No.
No, okay.
His evidence on that was, well, I've shown you the page, but his evidence on that was not challenged. Mr. Singh moved straight on to another question.
Sorry?
The cross-examiner moved straight on to another question.
Right, so there wasn't a cross-examination along those lines?
No. So I'd like to move on to malice, unless your Lordship has any more questions about probable cause. And two aspects of the case law to which I'll take you. First of all is the case of Williamson. That's page 1173. Well, I could just stop at the head note at page 1174, but I'll go to the paragraphs, the particular paragraphs in particular in the board's judgment about malice, and they begin at paragraph 11.1178, just at the last line of that page, working definition of what's required for proof of malice. And if your Lordships and your Ladyship will just read through to 12 and 13, I'll just emphasise at the end of paragraph 12, proving malice is a high hurdle, and 13, malice can be inferred from a lack of reasonable probable cause, but the finding of malice is always dependent on the facts of the individual case. And then, in the facts of this individual case, the board turns to malice at the bottom of paragraph 16 on the next page, and then paragraph 17. So makes a finding that, or Kerr makes a finding that it wouldn't have been unreasonable to continue to harbour suspicions about the defendant. And then
Sorry, where this is?
at the bottom of paragraph 16, which is page 1180.
Yes.
And this conclusion, now I'm reading from 17, this conclusion bears directly on the question whether the prosecution can be inferred to be malicious. Where there's absolutely no basis for suspicion, especially where that's accompanied by an apparent reluctance to proceed with the charge, one might draw such an inference. But that was not remotely the position here. And I will also turn to Juman, which is the third case in the supplemental authorities bundle. That's the judgment of Lord Toulson. And malice is dealt with at paragraph 17 onwards, which is page 52 of the supplemental bundle. So, the board would reject the appellant's...
I'm sorry, I've just got to this out. What page?
Page 52 of the supplemental.
52, thank you.
Paragraph 17 in Juman. The board would reject the appellant's attempt to treat the first respondent's alleged failure to carry out sufficient investigation before charging the appellant as amounting to or equivalent to malice, or similarly, the attempt to treat recklessness as tantamount to malice. Reckless is not a suitable yardstick for the element of malice in malicious prosecution. And then over the page, the essence of malice is described. And then paragraph 19. A failure to take steps which would be elementary for any reasonable person to take before instituting proceedings might in some circumstances serve evidentially as a pointer towards deliberate misuse of the court's process, but sloppiness of itself is very different from malice. Now, before I go on to the judge's findings on malice, and make
interesting, the citation from Willers and Joyce, there it says the most obvious case is where the claimant can prove the defendant brought proceedings in the knowledge that they were without foundation.
In the knowledge that, yes.
I suppose that's more than just from the absence of
yes.
a reasonable brief, yeah.
So, in terms of the statement that one can infer malice from absence of reasonable and probable cause, I say, from reading those authorities, that statement is not to be read too permissively. It was read restrictively by the board in Williamson. If one is to infer malice without evidence of specific improper motive, so that's where there's no suggestion, there's nothing to indicate a specific improper motive. If one's to infer malice from absence of reasonable probable cause, one has to be satisfied, I would say, that the circumstances were such that the prosecution can only be explained by imputing an improper motive. And that's why in Williamson, Lord Kerr gave the example where there's absolutely no basis for suspicion, at paragraph 17. And the board was deliberately setting the bar high there because, as was said, malice is a high hurdle. And that's why they say it always depends on the factual circumstances of the case. Now, before I go on to the judge's findings, I would make this point. This was certainly not a case where there was absolutely no basis for suspicion. On any view, there were grounds to suspect Inspector Maharaj, even if, on the judge's view, they were not sufficient to amount to reasonable and probable cause. So this isn't a case where the prosecution can only be explained by imputing a proper motive without identifying a specific improper motive. In fact, of course, this was a case where a specific improper motive had been alleged. And that's pleaded at page 17, paragraph D. But it wasn't pursued in evidence, and it wasn't put to Superintendent Phillip in cross-examination.
What was that reference?
Page 17, paragraph D. That's the allegation that
Yeah.
he did it to prevent investigation of the real culprits who were political superiors.
And certainly, as I understand it, that's not relied on now before.
No, the reason why it's important is because it colours the judge's findings, and as I'll go through, because he keeps on referring to the suspicion and saying Superintendent Phillip should have been more careful, but he never imputes the motive to Phillip himself. And so we're in a sort of halfway where Superintendent Phillip a finding is being made that he was actuated by an improper motive. That's what malice means. But he's being effectively, if you like, convicted on suspicion without a direct finding being made against him and without direct evidence being adduced or put to him. So it's a rather dangerous finding, in my respectful submission. But the findings are page 360 and 361. So, paragraph 37. Now, I'll go back to 35 and 36, but I'm just identifying the specific finding before I go through the reasoning that led the judge to this point. In the middle of paragraph. So, with a preamble, jealously guard the processes from actual or perceived political influence. We must be careful that we don't stray into the territory of apparent malice, like apparent bias. But the finding, the complainant acted without reasonable and probable cause, and the court can and does infer malice, and finds that in preferring the charges against the claimant, the complainant was actuated by malice. Now, there's no express finding of what improper motive Superintendent Phillip had, and it's not clear that the judge does find an improper motive on the part of Superintendent Phillip. But if we go back to his reasoning, beginning at 35, you can see what was leading him there. He indicates that he had suspicions, at least, that if not Superintendent Phillip himself, then others were making allegations against the appellant for an improper motive. In fact, I dare say that must have been his finding about Jagannathan if he found that the claimant's account of the appellant's account of their conversation was true. And he says there's a risk that police processes were thereby being used for improper purposes.
So which paragraph is it?
Well, I'm sort of summarising what we're going through, paragraph 35 here and 36. And 37. Oh, yes.
Something. What was that?
Yes, now the judge said this was irregular. The Court of Appeal said there's nothing irregular about this at all, and I submit that it's right. But I'll show you. It's at... It's exhibited just behind Mr. Phillip's statement. It's page 741. So, page 741. So this is a memo from the Conservator of Forest to the Permanent Secretary in the Ministry. 9th of September. So by now, Jagannathan and his fellow officers have found the felled trees, and their investigations have progressed much further. They've also found the trees at the appellant's land, and they've heard from quite a few witnesses, and they've located most of the logs by now. And Jagannathan's encounter with Inspector Maharaj is recounted there. And then over the page, the Conservator of Forests expresses his disappointment that in this particular area of forest, one of the trees that was felled was the largest in the Western Hemisphere. It was the jewel in the Forest Reserve's crown.
Sorry, where is that?
It's over the page, 742. It's the largest teak tree in the Western Hemisphere.
Wow. That would take some chainsaw.
Yeah. And then you see that, so that's addressed to the Permanent Secretary. Then you see, handwritten, a note from the Assistant Commissioner of Police. So you can see that the Permanent Secretary has passed this memo to the Assistant Commissioner, and the Assistant Commissioner has written on it, ASP Philip, for investigation and early report, 11th of September. And you can see Philip's stamp on the next day in the fraud squad. He's received it from the Assistant Commissioner of Police. So he hasn't received this from the Ministry, he's received it from the Assistant Commissioner of Police. And there's really nothing irregular about this at all. If the senior official in a ministry receives a report that police officers are engaged in illegal felling or suspected of being engaged in illegal felling, the person to send that on to is a senior police officer, the Assistant Commissioner. And it's no surprise the Assistant Commissioner then appoints a very senior investigator to go and investigate. And there's simply nothing irregular about this at all, and the Court of Appeal, as the Court of Appeal said. But
in any event, you say there's no basis for an improper motive of any kind, let alone the one pleaded.
That's right. And when you look at the judge's reason, we go back to the judge's reasoning now at paragraphs 35 and 36. If I may summarise, he's saying, without saying that Superintendent Phillip had these motives, some people may have had motives for making these allegations against Inspector Maharaj. And the police service must always jealously guard its processes from political influence. So he's saying there's a risk that the police processes were being used for these improper purposes. But he's not making a finding that that was Superintendent Phillip's motive or purpose. What he's finding is that Superintendent Phillip should have been more careful to guard against it. So if you look at paragraph 35, about 2/3 of the way down, an officer with the seniority that Philip had at the time should have exercised a greater degree of caution. And then, last line, the accused was himself a senior police officer, and in such a circumstance, caution should have been exercised to ensure that no harm would be occasioned to the public's perception of the police service, which, in my submission, is not a relevant finding for malice. And likewise, paragraph 37, the police service must jealously guard its processes. Given the allegations made by the claimant, greater care should have been exercised by Officer Phillip. And then he goes on to find that Phillip was actuated by malice. There are further pointers when the judge turns to exemplary damages at paragraph 59. Page 368. So, paragraph 59, the facts on which the charges against the claimant were premised were fundamentally flawed and deficient. Officer Phillip's decision to charge the claimant without the requisite evidence was in the circumstances reckless, slightly worse than careless, but still not malice.
Well, recklessness may approach malice.
Well, not according to the board in Ginny. They've just taken your lordships to the passage in Ginny where the board said reckless is not a proper yardstick for malice in malicious prosecution. He's not saying that he's not using recklessness there in the sense that a reckless belief is dishonest. He's saying a decision to charge was reckless.
He's there talking about exemplary damages.
Yes, he's now talking about exemplary damages.
So he's looking at the state of mind for exemplary damages.
Yes.
Which would be recklessness.
Yes, indeed. But
so there's nothing wrong with that.
No, but what I'm attempting to do is to find the high point of what the judge finds about Superintendent Phillip when we try and explain his decision that Superintendent Phillip was actuated by malice.
Right.
And that's the highest point there. I'm not saying it was wrong as regards exemplary damages. And finally, in the same paragraph,
well, you do submit there was no basis for it on the facts, but you would submit that you would accept that in relation to exemplary damages, recklessness may justify such an award.
Yes, I accept that. Yes.
Yeah.
And I think from your citation of Williams and the Attorney General, Williamson, it's clearly stated that an absence of real and proper cause may found an inference of malice, but it depends on the facts.
Yes.
Yeah.
Yes. And the example the board said it gave in Williamson was when there's absolutely no reason to suspect. And an example in a previous case is where even if you have no idea what the improper motive was, this prosecution can only be explained by an improper motive. Well, of course, in this case, there were grounds to suspect, even if the judge found that there weren't enough for a reasonable probable cause. So you're going to have to find more than just an absence of reasonable probable cause in my submission. And the final if you like, example in this run of examples I'm giving is the same paragraph. It's about 8 lines in. The complainant disregarded the very serious allegations that were outlined by the claimant, and this approach was ill-advised. So the worst we have about Phillip's decision to prosecute is that he should have been more careful. The decision to prosecute was reckless. The decision to disregard the other line of inquiry was ill-advised. And none of those in my submission amount to a malice.
Well, contumelious disregard? That's pitching it pretty high, isn't it?
Contumelious disregard for the claimant's rights and his reputation, but not a
Well, it's clear what is being said here. What's being said is that Phillips was instructed by the ministry, who had unlawfully requested felling and for their own personal gain, and he was being told, not only do you not investigate this, but we want you to go after Maharaj and keep him quiet. I mean,
Yes, my lady. If that's the underlying finding in the judge's mind, he should have made it express, and it should have been put to Superintendent Phillip. None of that was put to Superintendent.
Well, that's a different point, but I think that the fact that he may have expressed it.
Well, perhaps my first
colourful
objection
terms than I just did.
My first objection is the more pertinent one. The judge didn't actually find that, and if he has in mind a specific improper motive and has in mind a finding that Phillip was instructed by the ministry to go after one person and avoid the ministers, he surely should have made that finding.
Yes, it shouldn't be mealy-mouthed about these things.
Yes, my lord, yes.
Anyway, we're coming to the end of your allotted time frame.
That's it. That's it on malice. Apart from, if I could just commend to the board the Court of Appeal's reasoning too, which is at page 536, paragraph 72. I might have 5 minutes more, I think, but...
Well, I've given you an extra 5.
Well, I'm just thinking that my learned friend overran.
I know, we started slightly late and he overran 10. So I'm taking at least 5 off its replies.
Yes.
Anyway.
Thank you.
Because you can.
Yes, I will. The Court of Appeal's reasoning on malice is at paragraph 72. And they make the point, very quickly. First of all, they make the point that the investigation was exhaustive and thorough. And they're in a better position to make that assessment than the judge, because, as we saw, he wasn't aware of all the material gathered by Superintendent Phillip. Secondly, they make the point that there were grounds to suspect the appellant, and as we saw from Williamson, that's relevant to whether malice should be inferred. Third, they make the point that, considering all the evidence, it didn't point to other viable lines of inquiry. And then they identify the sort of matters that would need to be proved if malice were to be established, and make the point that there was no such evidence against Superintendent Phillip.
Yes.
I've just got to briefly pick up on a couple of points that came around this morning. On the question of the significance of the no case finding, my lord, it rather depends. I think much of this has already been discovered, but I would add one further point. It doesn't just depend on whether there was an objective flaw in the evidence rather than evidence not being believed, but it also depends on how counsel presented the case to the magistrate, because this is a case of circumstantial evidence. It would require great care and skill from prosecuting counsel to make sure that all the connections were joined together, and that's beyond Superintendent Phillip's control.
Yes.
One of the last points my learned friend made was about the log arithmetic. 23 logs were removed, 14 were found at Ragunan, and 20 were found at Barrackpore. That arithmetical point doesn't go anywhere in terms of undermining the evidence in my submission, because a tree may be cut into a number of logs in order to move it. You might fell one tree and find 10 logs. And that's also the evidence of the... If you recall,
Yeah, well,
I don't probably
if you're talking about a tree that's 12 foot thick, you're not going to get the whole trunk on the back of one lorry.
No, and if it's...
It was the circumference, I think, wasn't it?
If it's as high as this ceiling, you're not going to get one log on the truck.
Yeah.
That's why Inspector Maharaj went on the 4th with a log cutter as well as a tractor.
Well, yes, we can't really assume that he was guilty of this. He was acquitted apart from it.
Yes. And we also know that not all the logs at Ragunan and Trace came from the site of the felling, which wouldn't be surprising if somebody was running an operation. They wouldn't be cutting from only one site. Finally, my Lady Rose raised the point about Ross Cedino's evidence. When you see what Inspector Maharaj told Superintendent Phillip in his investigation, he did not tell him about Cedino. It's 794.
I'm sorry, I missed that page.
Page 794 is Maharaj's statement to Superintendent Phillip. And Cedino wasn't pleaded either. You'll see his name on the list of potential defendant witnesses before the magistrate's court, but he wasn't pleaded in the case before the judge. He didn't end up giving oral evidence either. Partly it seems because the defendant's counsel objected because Cedino hadn't been pleaded. You can see it because she seeks to stop counsel cross-examining Phillip on Cedino as an alternative explanation on the basis that he was never told about it and it wasn't pleaded. Those are my submissions.
Thank you very much. Yes, Mr. Carter.
A quick rattle through, if I may. Can I deal with some of the points that have been raised then? Question of the staging log. The signature is illegible. That is why there could be no cross-examination.
Log is an unfortunate word to use. You don't mean a log, you mean...
The station record. So there was nobody to whom a question could be put in cross-examination as to the meaning of the entry.
Yes.
De novo. when he gave evidence at the magistrate's court, it was predictable that whatever he said, he would be cross-examined. Well, if he said something which was contrary to the interests of Mr. Maharaj and inconsistent with the statement he had made, it was predictable he would be cross-examined on that statement, and that statement would be put to him, either adopted or not, and the inconsistent statement might become an exhibit. Yeah. In re-examination, if prosecution so wished, they could produce via him the other statement, which my learned friend describes as the coming clean statement. So all that information would be before the court, the magistrate's court, on which he could make a decision, and on which the High Court judge could make a decision. Dinu was not called by either party in the High Court. And so therefore, the High Court judge was doing the responsible course, having regard to the existence of that evidence, the likelihood of how it would transpire at the magistrate's court, in considering whether it was reasonable for Mr. Philip to consider that evidence capable of sustaining a prosecution case.
So what's the submission that you're making?
The submission is that it was irresponsible and unreasonable of Mr. Philip to think that Dinu was capable of sustaining a case so as to make it fit for trial. Nareen. His evidence, his statement was inadmissible, always was inadmissible, always would be inadmissible. My learned friend has factored from it a scenario which is entirely hypothetical and has no basis, I would submit, in evidence. Describing him as the woodcutter is not something that could ever have featured in the case against Mr. Maharaj.
I didn't mean to imply that he cut that was his job. I didn't mean to imply that he cut these trees. I'm just saying that was his job.
Okay, well that was the word used, so I'm taking it at face value. I accept that it could mean either.
What happened to Nareen, the prosecution against Nareen?
The case was dismissed.
What, at half-time, or did it run?
At the magistrate's court.
Yes, but at half-time?
On a submission.
So he got off at half-time?
He did. In fact, can I take you there straight away, please?
Well, if it's common ground that that's so, I'm probably happy to take it from counsel.
I apologise if I gave the impression that I was saying that Nareen was the person who felled the wood. I meant to say that that was his profession, woodcutter.
Okay, I misunderstood. I misunderstood the implications of it. Can I give you a page reference rather than reading it out? Electronic record, page 671, is a submission on behalf of both defendants. There is no reference, no submission relating to the absence or presence of a licence. It simply didn't feature. So that cannot have featured in the magistrate's decision. It is rather rubric in terms, which I'm pleased I don't have to read it out. There is a response submission by prosecuting counsel at page 672, which I can read out because it's very short. Persons before the court is charged with illegal felling of trees with no permit, not with aiding and abetting, you will notice. Mr. Ramnarine gave evidence and tendered maps. Statement of Boise Alley was employed by defendant to remove trees with his defendant number one, that's Mr. Maharaj, to remove trees with his tractor. The wood was later discovered not far away. I'm asking the court to rely on the photographs and the statement of the defendant to Nareen tendered into evidence. The prosecution was inviting the court to have regard to the inadmissible statement of Mr. Nareen. Now I know, I learnt from submission, this is prosecuting counsel, not Mr. Philip. But it means that Mr. Philip effectively had been relying on that statement as part of his unreasonable belief that there was a case to answer. And then it goes on to say, I agree that the judge's rule was flouted, which relates to the taking of a statement.
Sorry, where are you reading? Page
672.
672, my lord.
672. Right, thank you.
Now, unlike the respondent, we do not submit that this board should depart in any way from its recent judgments about the meaning of malicious prosecution or the elements within it, and particularly from the recent decisions about the circumstances in which it is right for the Court of Appeal or an appellate court to intervene. If there is material which requires judicial interpretation and application of a judicial principle as opposed to fact-finding and inference-making, then if that is what the Court of Appeal did, it was right. But we submit it went further than that and actually substituted its own opinion and findings of fact and making inferences from fact without having had any regard and without even referring to the judge's findings of fact and his opinions about the witnesses' evidence and their credibility. And so in doing that, in failing to even have that degree of deference to the trial judge's principal function, they overstepped their bound. It's suggested, and the Court of Appeal expressly say at page 360 that the learned judge looked at the evidence in silos. Well, in a sense, I suppose it could be said that he did. But because what he did was he analysed certain aspects of the evidence which I've been through from pages 352 through to 358, I won't do it again. And then he went through item by item. Yes, in some cases, he perhaps overstated things or made an error. But what he did was he had regard to various aspects of the evidence, which had he not done, he would no doubt have been criticised for saying he failed to identify which aspects of the evidence were significant for what purpose. And what he did, therefore, I submit, at pages 358 through to 360, was to identify those factors in the evidence which influenced his decision and why they did so. And that was his role. My learned friend referred to the case of Glinsky at page 1414. It's a passage which I hadn't referred your lordships to, but is of some pertinence on the issue of making inquiries. What Lord Devlin said in the second paragraph on page 1414 is 6 points are settled about the question of reasonable probable cause. First, the question is a double one. Did the prosecutor actually believe, and did he reasonably believe, that he had cause for prosecution? Secondly, provided that the defendant has made sufficient inquiry, the facts on the basis of which the question has to be answered are those, and only those, known to the defendant at the material time. So Lord Devlin regarded making sufficient inquiry in order to ascertain the facts upon which a decision could properly be made as a critical part of the process. Now, I accept, of course, that a prosecutor is not required to run down and explore every rabbit hole which a defendant or defence lawyer seeks to trap him with. But a prosecutor is required, I would submit, to investigate and to make reasonable inquiry to ensure that there really is a case fit to be put on trial. That is what the law requires. It is also what the Code for Prosecutors require, that there is periodic review of the sufficiency of the evidence in order to support a reasonable prosecution. Oh yes, Mr. Dinu. The learned judge had reference to and regard to Mr. Dinu's evidence. He dealt with it in detail at pages 353 through to 354. And so it wasn't something that he disregarded or regarded, even though Mr. Dinu had not given evidence in front of him, he had regard to it, and had regard to it by applying the proper test. Namely, how could Mr. Phillip have anticipated that this evidence would turn out and how it would appear before a court? That is the proper test. He was saying, I put myself into Mr. Phillip's position. Do I conclude from the evidence available to him that he could reasonably have concluded that there was sufficient evidence, there would be sufficient evidence to make a case fit to answer? It's notable, finally, if I may say so, that the prosecution case against Mr. Maharaj was that he had felled and had carried away the logs. The notion of joint enterprise was something which came at the Court of Appeal. And it is supposition, and it is seeking to take a point which actually wasn't really before the court. Because before the court, the question was whether Mr. Phillip reasonably believed that there was sufficient evidence to arrest, to charge, and to prosecute Mr. Maharaj for felling, as in cutting down, and for taking away the trees. And the evidence that the prosecution relied upon was the very fact that, according to Mr. Fiddler, he was seen taking away the trees. So therefore, to try and create this effectively a miasma of an alternative way of prosecuting, which was never relied on by the prosecution as a justification for undermining and overturning the High Court judge's decision, is, in my submission, unjustified. So unless I can assist you any further.
No, thank you very much, Mr. Gardner. Well, the board is most grateful for the detail and careful preparation to council submissions and to any teamwork that went on behind the scenes, which we can get at but can't necessarily see. And we will take time to consider our judgment. Thank you. Court's adjourned.